Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
Hello guys, you are once again welcome to PENDREAM TV, your number one political hub in Ghana and beyond. Today I would like you to join me listening. Before you go, if you are a new member you have not yet subscribed, please do so. Share the link, subscribe, and also make a comment after listening to what you have heard and your option or your opinion that you think about this video. Thank you. Be right back.
Good morning. How are you?
We're doing very well. And once again, we're grateful that you've been able to make time. Now, Alex, let me first of all find out from you. What are your general thoughts about what happened in court yesterday? I mean, there are some specific questions that I want to ask, but generally, from everything you've read, everything you've seen, what do you make of what happened in court? Help the Ghanaian to understand exactly what happened in court yesterday.
Thank you very much. Let me, first of all, have a disclaimer. I'm not Ofori Atta's lawyer.
Right.
I don't speak for him or his team. I have not had opportunity to review his files. So any comments I will make will be in general terms as to the normal immigration practice and the best of my ability, how I can educate Ghanaians with regards to what is going on. But I've had opportunity to read a few write-ups, and I watched some of the videos that have been put out. But there is something that I want to put across. I don't know who had the audacity to make the recordings, and I don't know whether the media folks who are showing those videos were given permission by the court to record. Because to the best of my knowledge, no one by law is allowed to record immigration proceedings. It's prosecutable. And people who are caught doing that can be prosecuted. In fact, they don't allow that in immigration court at all. And that's the reason why they don't even allow you to bring your phone unless you are a lawyer or you are an officer appearing in the courtroom and you need a phone to transact business. Apart from that, you are not allowed to even bring any recording device in there. So it's a caution to all my friends and family members and Ghanaians in general, and that people who had opportunity to log on into the conference and record it, it's against the law and they have to be very careful.
So, but Alex, this is some fascinating insights that you're sharing with us. The fact that it is not standard practice for people to record court proceedings, especially that which has to do with immigration, and share it publicly. So the next question that I have for you before you even proceed would be, do you think that this is something that the court would want to take up, first of all, investigate who did this, and subsequently punish or apply sanctions on that person? Would you think the court will do that?
They might do that. They might do that. And this whole Ken Ofori Atta's case, I don't think we are taking it serious, and we are actually giving Ken Ofori Atta a lot of information or a lot of documents to defend himself. Ghana as a country, pronouncements, our leadership's statements, our media write-ups, our actions is giving him enough, if I was his lawyer, to argue that his life is in danger. Because the things we are doing, the things we are saying cannot be far from the truth. Immigration proceedings has nothing to do with criminal proceedings. And unfortunately, we have made it sound like that. So let me walk you through exactly how it works.
Okay.
So, I mean, we all can educate us.
Again, before you do that, I beg of you. What is wrong with the public following this case? I mean, it's of public importance, isn't it?
There's nothing wrong. But Imoro, let me share with you. Do you know how many Ghanaians are going through immigration proceedings right now?
Okay.
And when was the last time you heard the ambassador reporting on the Ghanaians who have been in court, some of them who have been in jail or detention for a long period of time?
But Alex, sorry about that, Alex. Sorry about that. This is a former finance minister of Ghana. This is somebody Ghana wants America to return or to extradite to Ghana to come and face some criminal charges. I mean, doesn't that make it a unique case? Different?
Nothing to do with immigration.
Okay.
Moro. That has nothing to do with immigration. And we are confusing the two proceedings.
Right.
Okay? So here we have been told that Ofori Atta was adjusting his status, which means he might have used a family member to file an application for him. That was the impression we all read from the onset. If that is the case, then it means Ofori Atta has equities to step out, because he has already filed to adjust. Yes, his visa might have expired, but by law, the mere fact that he had filed to adjust does not invalidate the fact that he has applied to adjust. His visa might have expired, but once he applied, that can cover him. So it's a technical violation that should not put him in jail. But from what we are all now reading, it does not look like he had actually filed for any adjustment. If anything at all, he might be filing the adjustment now. So all this time that we were saying he had filed adjustments and he was trying to stay in America, where was that information coming from?
Okay.
That is where my concerns are.
All right.
So we are actually building a case solid enough for him to use to establish that we are making things up that did not even exist in the first place. And I'm saying this based on what we are discussing now and the information you've given me. Because if he has already filed, let's say, an I-130 that is waiting for adjudication, that should be on file. They should have it in court. And that will be a basis for him to even be given a bond to come home.
Okay.
But let me walk you through simply how this thing works. So let's assume it is true of Ofori Atta, or let me admit that he has not filed any documentation to adjust his status. He has overstayed his visa. We all know why he overstayed his visa, that he was in a medical procedure. But I'll be surprised, knowing that he has lived there before, going to school there, his family are citizens, that he overstayed his visa without applying to extend. Sometimes when you apply to extend before expiration, the response does not come timely and you'll be left in a limbo. So he might have been in a limbo while he was picked up. But once you are picked up and taken to detention because you don't have anything to hold you in America, it is DHS that will pick you up or ICE that will pick you up. They have the right to give you bond. They can refuse you bond if you request for it. Once that is refused, they will issue a notice to appear, which is the NTA. Now, when you go to the bond hearing is separate from removal hearing. So his first appearance will be a bond hearing, which his lawyers can make an oral argument or an oral request for him to be given a bond. You do that, the judge can say yes or no, because the judge might not have all the files. Because remember, bond file is separate from removal file, and he might not have enough in there. But that does not end there. He can then move on to the master hearing. And I think they had requested, based on the video I listened to, the lawyers had requested for expedited processes, and they had requested to be heard in camera. That is a right of the defendant to request. At least one of them, either prosecutor can ask for it or the defendant can ask for it. It is not because he has anything to hide, but it is because of the sensitive nature of some of the things he would like to proffer to the court. So you can ask for it. If he was going to disclose certain information that is sensitive, that will be prejudicial to Ghana, he can ask to be heard in camera. If it's a personal issue that he's going to disclose that he doesn't want people to know, he can ask in camera. And so he's within his rights to ask for those things. Now, once the NTA has gone on, you have appeared, bond has been requested, denied, you move to master hearing. The charges will be read to you, you either admit it or deny it. Now, if you deny or admit, Some you admit, some you deny some. The next thing is for a full hearing to be had, for the judge to listen to what you are denying and what you are proffering. That is the individual hearing. So he's going for individual hearing, for that's evidential hearing. You put evidence up and you'll be cross-examined, and then you answer it. If the judge believes you that you are credible enough, then you can move forward with it. At this point in time, if Kennedy Ofori is not applying for family adjudication, I will probably be adding asylum to it, because if he has credible fear for his life, then he has a right to ask for it. And he could ask for it. And he'll be listened to on equities. For everything we have exhibited from day one, he could ask for it. And in fact, even in immigration hearing, you can be prosecuted in absentia. So if Ofori is given a bail and he absconded, he can still be adjudicated in absentia. So they do give hearings and adjudications in absentia. Now, after individual hearing, the judge will give judgment, and then you have 30 days to appeal. Either prosecution will appeal, or defendants will appeal. It can go to the Board of Immigration Appeals, and if that one also does not work, you can go to federal court and get your case heard. And then if you hit, then you hit. That's it. And maybe one of those hearings you may get approved, and then you can go home. However, the mere fact that he has been denied bond does not mean he cannot request for bond throughout the process.
Okay.
Once the oral bond has been requested, has been denied, subsequent bond will have to be in writing. In this case, you write your briefs, you give your supporting documents, you establish the reason why you have to be given the bond. And the judge's role is to evaluate and see whether you are eligible for bond. He has to consider whether your release will pose a danger to property or persons, or whether the alien is likely to appear for further immigration proceedings, and whether the alien is a threat to national security. If he can establish any of these, that he does not pose any danger to property or persons, or he is not a threat to national security, and he has equities he can stand on, I do believe a bond can be given. Maybe not preliminary, the challenges he's having, but he can make a case to get a bond. Unless the judge does not have jurisdiction over bond, or he has left voluntarily, and therefore the bond request is moot.
Okay. And
there are a lot of reasons why a judge will not have jurisdiction over that. So I'm a little bit confused. In as much as it's a public interest case, we have to be very careful the way we are asking for him to come to face the law in Ghana or give account to his stewardship. But the way we are going about it presents the form of persecution, not prosecution. And we have to be very careful about that, not to give him equities, which I think we have given him enough for him to be able to use on his case.
Okay, let me ask you this. Prior to Ken's appearance in court, albeit virtually, we noticed that almost all the cases that were heard prior, right, were done publicly, off camera. Now, this time around, when it got to Ken's turn, it started with, and then, we were all watching and following virtually. And then after a few minutes, we're told that he's requested for an in-camera or private hearing. You have been practicing the states for many years. I'm sure you've defended people who have committed all kinds of immigration, violated all kinds of immigration laws and so on. Under what circumstance would the court grant this request for an in-camera hearing or a private hearing?
There are a lot of reasons a court will consider to do that.
Okay.
And as I shared with you, one of the major things they look for is sensitive information.
Okay.
Sensitive information. I've had opportunity to defend juveniles where, because of the testimony they were going to give, the kind of trauma they went through, they would not be allowed to put it in public domain because there might be other or subsequent investigations that might have to go forward that they do not want to tilt their hand for the public to know about it. So if you listen to the judge carefully, he said the prosecution and the defendant have the right to request for in-camera hearing, and he has to give it because that's their right. However, if they go into camera and whatever he needs to discuss is not sensitive enough, the judges will not accept it unless they will hear a few things that you want to discuss to make determination that, oh, this might be a sensitive subject and I don't have to put it in public domain. It is not a matter of him trying to hide his proceedings. I don't think that is the case at all. But it depends on what he's about to proffer to the court. That might be a sensitive subject matter, whether because of his position as the Minister for Finance for Ghana or because of something else personally that he doesn't want to be public. And he has a right to do that.
Now,
and I don't think we should read too much into it.
Okay. Now, the first bail bond application, as you rightly pointed out, was made orally. Now he is doing it officially, so in writing. Now, does the fact that when he requested it earlier, that he should be allowed to go home, that's what this whole bail bond thing is about. He should be allowed to go home whilst the case is heard, subsequently. Is that going to make this particular request that he's making more difficult, or you think that the lawyers have some more information or some new, fresh, compelling evidence, right, which they have come across, which they intend to make available to the court to be able to make a more compelling or a stronger case, so that the court will say, well, you made an oral argument based on information you gave us, we didn't grant it, but now based on what you're telling us, we will grant you that bail bond request, what you lawyers call exculpating evidence, a compelling evidence. You know, I'm actually considering reading laws anyway, but that's to say, you know,
it is possible.
Yes,
it is possible.
Are we to assume
you may be on it?
Yes. Are we free to make that assumption?
Yeah, it is possible.
Okay.
Yes, we are free to make that conjecture. I mean, it is possible.
Okay.
But you have to understand something. As I explained to you, the first oral request is when you are arrested and you are taken to DHS. You will tell them, listen, guys, you know, let me go home. I'm not a flight risk. I'm not going to go anywhere. You pick me from my house. I'm home. I don't have any criminal record. I'm not harmed to anybody. Maybe I'm sick. I'm taking medication. Okay. And they will then look at their files and make a determination whether they will put maybe own recognizance, $1,500, $1,000, $5,000, maximum $10,000. If you have killed somebody, criminal, that somebody's chasing you for maybe $20,000, $25,000, they do sometimes do that. But if DHS says no, then they have to issue an NTA and take you to court. That is when you make your first request orally. The judge might not have all your files, he might not even have your master file, and he may not have heard a lot about your case, and you may say no for now. Then you have the right to go and do bond redetermination, where you file official briefs and establish why you think your client should be released. And then the judge will take it in advisement and make a ruling on it, whether you're going to be released on your own recognizance, whether you're going to be paid $1,000, $500,000, or $5,000 or $10,000, and then you'll be bonded. And that money is meant to be given to you once your case is over. So far as you show up and you do all those things, your money will be given back to you. No harm done. But even if bond is not given, they see there's a lot of implications in this whole proceedings. Once the case is completed, there is always detention, redetermination all the time. Even those who have been adjudicated to be deported, who have not been deported yet, are allowed to go home because the place might be choked, right? And they have to release people. And they normally look at those who are not flight risk, who are not national security risk, who do not have any threats, are not going to threaten the community or the persons or property that they live in. So even in detention, he can be released based on assessment by the detention center so that he can come home. So the bond request is not over. And throughout his whole hearing process, he can request for bond over and over again if circumstances change. And then he can come home. But I think based on, I haven't read anything yet, but based on what I've read on media and listened to, I think his lawyers will do a good brief for the court to consider to grant him a bail very soon.
Is he entitled, right? Is it entitled to opt for self-deportation with this period and say, if you don't grant me the bond, I want to go home. Deport me.
Oh, anytime. He can do that if he wants to. He cannot request for step. He can sign for step and then they will let him go. He will stipulate to the fact that he wants to waive all his rights and he wants to return back to his country. And the court will ask him, I mean, how soon can you leave? He normally is between 30 days to 90 days. In fact, I've seen 120 days before. He can say 30 days, 120 days. In between there, the court will grant it. He will buy his ticket, go and show it to the DHS. They will give him his passport, or sometimes they will take the ticket and add it to his passport. They will release him for him to go home. And then when he's ready to go, they will meet him at the airport and give him his passport and ticket, and he leaves.
So then, it's
not science about it.
That's fine, but Alex, what then happens to the substantive case? I mean, quite clearly he's breached immigration laws. The laws of America wants to deal with him. If he says he wants to go back home, what then happens to the real case? Does that mean that Americans are saying, well, even though you've committed a crime, go and sin no more? Is that what it is?
The crime for the claimed violation of his visa is removal.
Okay.
That's it. So immigration, you are not being put in prison. You are kept in prison or you are kept in detention for the hearing if you don't have equities to go. I do not think that Kenneth Ofori does not have equities to go home while his case is pending. But the worst that will happen is for him to be removed and he will come home. Now, it's not like you have violated our immigration laws and therefore we are putting you in prison. No, that's not how it works.
There's the Trump gold card, right? Which everybody is entitled to take advantage of. Now, what we're being told is that it is something that Ken Ofori is seriously considering. In fact, his son and his wife were told on Americans, and they're looking at all options available to make sure that they file and make him a citizen of America so that he doesn't have to come back home. My question to you is, while he's on trial, he's made a formal request for a bail bond. Can the two applications go side and side? Yes, he's being heard in court, but at the same time, another process has been initiated to make sure that he's made a citizen of America. Can the two go side and side?
He can file any equities he so deems. He can file asylum. He can file for the gold card. He can file the family visa process. Anything that is eligible, he's eligible for, he can file once he appears in court. He can file anything. And the court will listen to all of them and make a determination which one he's eligible for. So he is entitled to those things, unless he chooses not to pursue it and he wants to pick up and go. He's entitled to all those things like anybody else.
Right. I mean, whilst watching the proceedings, albeit very briefly last night, I made some observations, and I want to just run by. It really doesn't bother the substantive case, but I looked at his dressing, for instance. I mean, you know, is that a dressing? Is that an attire for detaining a prisoner, or is that his own personal attire? Tell us.
He's in detention, not a prisoner. But you see, we are used to the orange jumpsuit.
Okay.
Most of the time, the orange jumpsuit, you are going to see it in jails, right?
Right.
Not detention facilities.
Okay.
And of course, where he is considered to be like a jail. But because it is for immigration purposes, they normally don't. I've not seen them using the orange jumpsuits. They normally will use a brown jumpsuit, a blue jumpsuit, or the multicolored black, whatever, that he was wearing. So it's a normal jumpsuit. You could see he was wearing something under it.
Yes.
Which tells me the place where he was cold, and he needed to keep himself warm. And it's always cold in the air condition is always blowing. So it doesn't matter whether they are heating the place, it's still cold. And coming from a temperate area, he might be feeling chilly in there. Yeah. So he needs to wear multiple.
Well, he didn't look bad in that attire at all. He didn't look bad at all because we're used to seeing him wearing white.
Oh yeah.
You know, from top to bottom. Yeah. But now for the first time he's wearing a non-white attire. That's not bad at all. So after all, he can wear something
which
is not white, which is not bad. Yeah, it's looking good. He may want to consider other colors. But just briefly, just briefly, my last question to you, my penultimate question to you. I mean, I noticed that the judges were sitting. So it was a virtual setup. So the judges were sitting somewhere, clients were sitting somewhere, and then I saw the deputy consular person for Ghana, sitting somewhere. I mean, we're seeing them in different cameras. Is that standard practice in America where these cases are heard virtually?
Yes.
Okay.
And you see, in one of the videos, I saw the courtroom where the judge was sitting on his bench and the courtroom was empty. Ordinarily, if he was not in detention, he was at home, he and his lawyer might have appeared there.
Yes.
But in immigration court proceedings, bond hearing and master hearings can even be waived. You can even file master hearings and don't appear. You just answer it. Your lawyer will answer it on a briefing and submit it to the court, and then you'll be scheduled for individual hearing. So your first appearance, you can always skip it. In this particular sense, because he is in detention and they have video facilities in there, the court normally will take people to the such facilities, and he might not be the only person there for immigration hearing. So they will move people to those facilities purposely for hearing, and maybe after the hearing, they will go back to their mother facility until the next time that they need them. Or sometimes they stay there until their hearing is over, and then they'll be relocated. So this is not new. Now, if even he was at home, he and his lawyer could have applied to appear via phone or via video in the lawyer's office. And most of the time, the lawyer would say, my client will come to my office and we will call the court. Or the lawyer will say, my client will be in Ghana and I will be in my office and we will call the court together. And so this is normal procedure. It's not something specially for him, but it's something we do most of the time.
And then again, this is a final question to you before you. I know you're very busy, man, because you have to attend to some of the clients. But here's the thing, Alex. We know the times.
Yes.
We know the times. This is Donald Trump's America, and how hard he's fighting immigration and so on. I mean, how likely is Ken Ofori Atta? How likely is he? Let me put it this way. How likely is he going to succeed in getting this bail bond request?
Moro, let me tell you something. I've seen it all. I mean, we've seen cases probably even worse than what you think Ken is going through. And we win some, we lose some. But this will not be the first one that we will have to wither it through. But I'll tell you something. Irrespective of the fact that we are not in good times in America when it comes to immigration, I think he has a very good shot with good lawyers who know the case and know what to present to the court. Everything is in the discretion of the judge. And I think immigration judges have always listened, in as much as they also have mandate to make sure that illegals are sent back home. They also listen to people who have good equities and can establish their equities very well with documentation, with testimony, and are credible to their testimony. If he can do that, I am very comfortable that he can win. If he doesn't come out credible, then he will lose his bidding to stay. But whatever processes he's taking, he's doing what he's entitled to by law. under the laws. So
the Trump administration's decision to temporarily halt immigrant visa processing, how is that likely to affect Ken Ofori-Atta? As he considers to apply for.
That's also a challenge.
Okay.
I mean, we've been discussing it. Myself and a few lawyers have been discussing it. So what is happening? We all don't know which application is affected. Does it affect only those relocating from Ghana to America, or those who are even in America adjudicating? Are they going to be affected? But at this point in time, we have all concluded that everything is in a halt, right? So if he has filed equities and there's a halt to proceedings with regards to adjudicating those applications, the court may take that into consideration. Although the court is not obligated to wait on you, but the court may take that into consideration and maybe release him, waiting for his case to be adjudicated with DHS before they proceed. I will not be able to tell. But you are right, we are not in good times when it comes to immigration in America.
Right.
But you may never know. You may never know which judge you are going to get. You may never know which courtroom you're going to walk through. You may never know the equities the lawyers will be putting forward to ensure that he gets a fair shake when the law comes to adjudicate.
All right. So thank you very much, Doc, for your time. I know that you're a very busy man, and
thank you very much for your time, and thank you for having me.
Yes.
Definitely.
Thank you. And my regards to the diasporan group. We're grateful.
Definitely.
Right.
Definitely. I will let Mr. Nkrumah and his team know.
And his team know. Thank you. Thank you very much.
We need justice.
All right.
Thank you for watching this video. We much appreciate your time and say God bless you for the good work you are doing. Please, if you have really enjoyed this video, please give a thumbs up by subscribing and liking the channel. Do share to other friends to also enjoy what is happening in the political arena. And the way forward, keep watching PENDREAM TV, keep questioning, and subscribe, turn the notification bell on to keep you updated always. Thank you.
I'm not PENDREAM TV. Now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.